So, but
I
do you
must
think
say
that
that,
okay?
yes. Oh,
Yeah.
go
So
on.
yeah, but do you think that perhaps we should face the realities of the fact that we are human and the potential of judges to align with one political party or the other is something that is very real. And for that matter, for instance, in the case of the United States,
Yes.
judges are nominated based on
Yes.
ideological grounds and they tend to
Yes.
lean towards one party or the other. And sometimes with certain
Mm,
cases, you tend to know
mm,
which way which judge is likely to vote.
mm, mm.
Should we take a
Well,
similar approach to the judiciary in Ghana?
well, for me, I unhesitatingly say, and I've said in conversation with some friends, I don't go out, a few people come and we discussions. I have often said that the United States judicial system is a bad example to the world, a very bad example, because they openly allow for the packing of their Supreme Court. They do it openly. Now, how do you have an independent judiciary in that manner? If you look at it, um, I confronted some judges who were on visit to Ghana and some lawyers from the US about the Al Gore uh, electoral case.
Versus Bush.
I asked them, I said, you in the US, you say you are the beacons of democracy in the whole world. And how did Al Gore's case go that way? They couldn't give me an answer, but they went back and sent a book uh, entitled The Scorpions of the Supreme Court.
Okay.
I think giving the background of the appointment of the justices from Frankfurter and all these people up to uh, recent times. I think probably to let me see the
Clinton. Mhm.
undertones
Yeah, okay.
uh, of the appointments. Well, I couldn't really uh, get it as they intended.
No, but because
From the,
I was reading the speech that you gave in 2013, and
yes,
you gave a long list of interferences with the judiciary since from Nkrumah's period all the way to even Lehman, um,
yeah,
Buzia, every regime. You cited cases that had the interference of the executive in the judiciary, which clearly
yes.
indicates that it's inevitable.
Uh, I wouldn't say it's inevitable simply because it happens. It ought not to happen. It could have been if the country and all the stakeholders were minded to do that, to prevent such interference, to succeed.
Okay.
If not 100%, to a very large measure. Let's move to the United Kingdom. Do we have such grievances about the English judicial system? I'm not aware
No.
of any fear of executive interference with the English judiciary. Yeah, I'm not aware of any instance, except the famous or infamous case of Liversidge versus Anderson,
Mhm.
which was a wartime detention case. And the court literally upheld the power of detention. It could not be questioned. I will remember the famous dissent of Lord Atkin.
Mhm.
I view with apprehension the attitude of some judges when face to face with the question of construction of a statute show themselves more executive minded than the executive. You know, the question is whether if A, has grounds to believe can mean if he thinks that he has grounds to believe. Well, so that is it. You can see the temperament of the English judiciary. With hindsight, we feel that in times of national security issues, um, I don't think that Lord Atkins' position ought to be upheld in the raw.
Okay.
Security, national security, the nation must uh, exist and survive before all other things can be considered and applied to it. But we all know that shortly after that wartime era, Lieutenant Sergeant Anderson was departed from uh, very liberally. And so that's an instance where it's possible
Mhm.
to have a judiciary that uh, cannot be manipulated executively.
Okay.
Although they're also humans, like
Mhm.
anybody. But English justice is really sound.
Yeah.
That's because their system is not, well, I think they have a long tradition of
Mhm.
judicial independence. Because until now it was the Lord Chancellor was appointing the superior court judges and so forth. But they are principled. They would not use executive, you know, uh, uh, malleability. It's well known that until the establishment of the English Supreme Court, the judges of the superior courts were drawn from the QC class of England. That was it. And the QC class, as we know, consists of the crack lawyers
Mhm.
of the English legal system. And so it's a question of merit, nothing else,
Okay.
you know. So it's a doable thing
Okay.
to have a judiciary that is truly independent. If
Yeah.
people at a particular country so wishes, and it's up to it.
Okay.
Uh,
Yeah.
so I know that is not possible to have 100% independence. Although I still, in the round, I do not see why, but I grant some dispensation in favor of your point of human fallibility.
Mhm.
But the margin of it should be so thin
Mhm.
that it cannot have a cumulative effect. Because, it's a panel of judges. And if you have only one or two bad nuts, they cannot hold sway over the important decisions.
Okay.